615, I think is the new number, the rule of sequestration to allow any expert witnesses for either side to be allowed to be in the courtroom during the testimony of experts for the other side. There's authority that allows that. It's within your discretion. I have just served the state with that today. It will not require extensive argument. I've asked the court just to consider it. Let me know whether or not that's something we can consent to. If not, it would require, as I said, no more than 5 minutes argument.
All right. And Mr. Petrie, I would confer with Ms. Patterson, Ms. Moore. And this was filed today?
Yes, sir.
And the clerk's office has been filed downstairs?
Yeah, that should be a stamped copy.
Yeah. And the district attorney was served with this. It looks like it was stamped at 1:23 p.m.
Yes, sir.
All right. And Mr. James, have you or one of your assistants received the copy?
Your Honor, we just recently received a copy. Yes, sir.
And what is the state's position? I know you just received it less than 2 hours ago. What is your position?
Objection.
All right. Lawyers, since there is a noted objection, what I will do prior to hearing additional arguments, since they just got served, that's 2 hours. Obviously, all the lawyers have been involved with the jury selection. I will take this matter up on Monday morning, and the lawyer represents, you can argue as long as you need to, and I will give you a ruling prior to opening statement.
Okay. Your Honor, just as a matter of housekeeping, I do not believe that we need a ruling before opening statements. It's just a matter of who gets to sit in the courtroom. I'm happy to do it, argue it whenever you want us to, but there's no reason to delay opening statements because of this.
Oh, in that case, I have no problems. We can do it right before, right after one of the breaks. Because you're saying, if I understand what you're saying, anytime an expert for either side is testifying, that person would want to, I know they're opposing it, would like to be present to hear that expert testimony.
That's right.
And I was going to ask the state when did they anticipate calling the first expert, but I can take it up. Mr. James, can I take it up later on Monday, or do I need to take it up early on Monday?
You can take it up later on Monday.
Okay. Let's just plan on, obviously prior to any expert testifying, that this be done later on Monday. So my plan will be, as you know, we'll bring them in on Monday, opening statements, and we'll go forward with presentation of evidence. Once we conclude for Monday evening, I don't know the time right now, we will deal with this matter at that point in time.
Yes, sir.
Okay? And let me locate my staff attorney, just so she can start working on this issue. So hold on 1 second. I'm going to hear from you, Counsel, Mr. James. Yes, Mr. James, you're up. Yes, sir.
Just for clarity's sake, Your Honor, my understanding of Your Honor's ruling or Your Honor's position is that their expert would not be allowed into the courtroom until Your Honor ruled, and that includes opening statement as well, that the rule of sequestration would be in effect until Your Honor ruled and allowed that said witness in the courtroom.
Yes, Mr. Petrie?
I understand.
Okay.
Yeah, I just wanted to make sure I was clear, that's all.
Yes. Yes. Until I have actually ruled on the motion to start at 1:23 p.m. on August 1st, yes. Neither side will be allowed to violate the rule or having any sequestered witness to be present. Obviously, there are other exceptions, but we'll do that on a case-by-case basis.
Yes, sir.
And as it stands right now, without anyone, I don't need anyone to reveal to me any particular trial strategy, this will be taken up at the conclusion, or near the conclusion on Monday evening. All right?
Yes, sir.
And estimation on time, and like I said, we'll be doing some research over the next 4 days also, will be less than 15 minutes.
Yes, sir.
All right, and this is just a legal argument, which is fine. Any other matters?
Nothing from the state, Your Honor.
No, sir.
Before I bring in the jury.
No, sir.
Defense?
No, sir.
All right. Mr. Deputy, bring in the jury, please. Yes, sir.
Welcome back to 11 Alive's coverage of the Sneiderman trial. Bill McKinney is our attorney, our analyst this afternoon. We are grateful for having him here with us, sharing his years of experience. And a jury is all set and ready to go. Monday is fast approaching for the beginning of this trial.
It is, and we're not sure, you may, Jeff, whether he's going to allow opening statements or they're going to reserve those until Monday morning.
Monday, feel free to move either podium, this was for the station, that's required to the floor, but you can move the podium wherever you wish. I'll complete that in a minute. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, you can sit in any seat. Technically, there are no assigned seats, but you can sit in any seat as long as everyone has a seat. Come on in, ladies and gentlemen, make yourself comfortable. I always tell ladies and gentlemen, if you like sitting on this end, come out first. If you like sitting on that end, come out last. That way everybody doesn't have to fall over you. Because during the break, you may be seated lawyers and parties. It's just that you just have to make yourself comfortable. And let me just give you some instructions before I release you for today. The deputy was nice enough to go ahead and give you the badges. I need you, while you're in this building, to wear those badges prominently on your clothing so you be easily recognized and identified as a member of this jury. And that way people are always cautious not to say anything in your presence, but court personnel will definitely be on their highest alert. And, it's just, and also, as I indicated earlier, on the back side of that badge is the office number. Obviously, things happen, emergencies happen. That way you can call the office and leave a message. The deputy, because we would do this routinely, has given you a pad and a writing instrument. Obviously, you take notes today, but I'm just giving you some preliminary instructions. Now, those pads that you have in the pencils, if you could, just write your name on the cover sheet and then turn them face down in the jury when you leave for the day. They're going to be in there when you get back. Nobody's going to look at your notes, not only today, but help. It's just that easier for managing that to leave them always in the jury room. If you, and I'm not saying you will, but if you do decide to take notes and you use that pad up, we will give you more pads. So don't worry about it. You can write as much as you want, write as little as you want. So we have a lot of pads to give you if you need to take notes during the course of the trial. And like I say, those badges, you will be taking those with you, and Jay will be giving you additional instructions on which interest you'll be using throughout the course of the trial. You will be given the parking code to assist you going in and out of the parking garage. And that changes, but we will update you on a regular basis when that changes. So you will be able to come and go out of the parking garage as necessary. I will give you hard times on which we will start each and every day. It'll be a soft time. I won't give you a soft time yet, but you will get an idea on when we'll be leaving, and so that you can have some normalcy in your life. The lawyers have indicated the case will take several weeks, and so just planning court. We're letting out early enough today so that you can prepare yourself so you can be here Monday on, so you can contact your employer and let people know when you will be with us. You are the jury. That's it. I mean, so this is it right here. The selection process has completed. This is it. I have to count on each and every one of you to show up each and every day with an open mind, ready to listen to the evidence that comes from this witness stand and any physical evidence, and review any evidence that is introduced during the course of the trial. Let me give you these instructions because I'm going to send you home. My habit is to say for the evening, but it's going to be several evenings because we're not going to get back together until Thursday. But because of some things that I just have to coordinate, we're going to come back together on Monday morning, and at that point in time, I anticipate starting the trial with the opening statements and then followed by the presentation of evidence. When I release you, and you've heard this already, but I got to say it again, do not discuss the case or allow anyone to discuss the case with you. This is a very critical process at this point in time. As I said, it's on our honor system. You're not going to be sequestered. You're going to leave here each and every day, including today. And I won't see you until Monday morning. But do not discuss the case or allow anyone to discuss the case with you. Do not stand near anyone who may be discussing the case. Do not look at any media coverage pertaining to this case. Obviously, we all go out, we interact, the TVs are on in restaurants and businesses where we are. If the TV's on and it appears to be I'm going to use the term news story, but it could be something else, and you think they're saying something about the case, walk away from that TV screen. Do not look at it. Do not read the teleprompter. Don't listen to it. But don't get any information about this case. I need you to do the best you can. Once I release you for today, do not remain upon the floor, because I don't want you to interact with anyone at this point in time. You should not interact with them. And I don't want you to hear anything or see anything you should not see. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research whatsoever about this case. Do not blog about this case while it's ongoing. Do not send text messages, email messages, or receive email messages about this case while it's ongoing. Do not go by any location that may or may not have been made reference to when I read the indictment to which all of these charges Mrs. Sneiderman has entered the plea of not guilty, and as I indicated earlier, she is presumed innocent unless and until proven guilty in the court of law. And at the appropriate time, you will have the indictment out with you, also with a proposed verdict form, but that is at the conclusion of the trial. You're more than welcome to bring something to snack in or eat with you any day, not just Monday, but every day if you wish. You can drink a beverage, a hot or cold beverage there in the jury box, but you can't eat in the jury box. You just have to leave anything that you want to eat there in the jury room. You will eat those, consume those items at the appropriate breaks. Throughout, and I would say this every day, but throughout the course of the trial, do not consume any alcoholic beverages during lunch. Or while the trial is going. When you go home, if you do consume, because you're over your legal, consume in moderation, because you cannot, and I don't want you to come to court the next day with a hangover. I can't say it any clearer than that. So if you do, just do it in moderation, at least during the course of this trial. Because obviously if you come to the building, I'm just generalizing that, and if the bath's on, you take an alcoholic beverage upon your personal address, it's a different issue I got to deal with. So all I can do is stress that on the front end. The deputy will return to you your cell phones, iPhones, and iPad devices when we finish this presentation. And each day, the deputy will collect those items up from you. You cannot have any cell phones, iPhones, iPads, any type of communication device there in the jury room. And I know he was mentioning to me, he has quite a few, so you have 2 phones, which is okay. And I know you're going to be in contact if it's possible. Because you're gonna go home and have lunch break. Can you only? I'm just asking, but if you got to bring, but it just makes a lot for him to have to keep up with every day. If you could come, if you have to bring one, could you only bring 1 phone? But you can bring as many as you wish. So I'm not limiting you, but I know that his box is full because of all the phones and but it just makes a lot for him to keep up with, which is okay. We will accommodate you if you got to have that kind of communication. But remember, they're not going to be with you during the course of the trial in the jury room. You only be checking the messages during the extended breaks, okay? And at the end of the day. But you're going to get them back every day. But those bigger items, the iPads and the laptop computers, it becomes very bulky with the number of you. But this is a request. And if you do bring them in, which is wonderful, please put them in the off position. The lawyers and the parties and the litigants and the people who, they cannot talk and interact with you, in particular lawyers. But I don't ever want you to think they're being rude or discourteous, and don't draw anything from that. Because the reason I keep saying this is courtroom 5D and what time we're going to start, because you're going to have to remember. Because if you see them on the elevator, although they're going to the exact place you're going, and you turn to them and say, which courtroom is Judge Adams? They aren't going to say a word to you. But I don't want you to draw anything from it, because that's why I'm telling you where you're coming back to on Monday, courtroom 5D, but don't draw any emphasis from that from the lawyers if they don't talk to you. Even if you see them over the weekend, you say, hey, how you doing, Mr. or Ms. Sullivan? They're not going to respond to you, because they're not going to communicate with you on any level. But I've told them that, they know that's the rule, but don't draw any emphasis from that, okay? They can't talk with you outside of the presence of court. We're going to reconvene on Monday morning, and I believe some of the school systems maybe start, I think the city of Decatur started this day, and I think some others may start on Monday, which is wonderful, which means more buses and automobiles going to be on the street. I just say that to let you know, wherever you're coming from, at home or wherever, it doesn't matter to me, you're going to have to leave there enough time to park your car. And I know this sounds very basic, but if people won't come to court late, I won't have to keep saying it. Park your car, come through the metal detector, ride the elevators, come up, and come through either this door or a different exit. We may have to set up, it just depends on logistics, because you're going to exit through a different door today. But we will accommodate you. But I just need you to be in that jury room physically by 9 o'clock a.m. 9 o'clock a.m. on Monday. 9 o'clock a.m. on Monday. Any logistical questions? Wonderful. Hearing none. Any communication that you have to do with the court, you're going to have to write it down. But no one is released. You are on this jury. Thank you very much for your patience. I thank you in advance. Have a wonderful weekend. I will see you on Monday morning, 9 o'clock a.m. Have a great weekend. Get some rest. All right? And you're going to be exiting through a different exit, so it's okay. Just follow the instructions of the deputy. He's gonna give you your cell phone back. Leave your notepads there, turn them face down. Continue to wear your badges. Take all your possessions with you if you don't mind. You can carry your possessions with you. And you just leave all those things there in the jury room. They'll be in the jury room. You come back on Monday. 9:00 a.m. on Monday. See you in 3 days. 9:00 on Monday a.m. You can be early, but you can't be late. 4 days. You can write everything that's right. You can write, thank you. All right, lawyers and parties, you may be seated. All right, is there anything else for the record for the state,
Nothing from the state, Your Honor.
from the defense?
No, sir.
All right, any other, let me just very quick, lawyers, would you approach, this is kind of one last issue.
Welcome back to 11 Alive's coverage of the Sneiderman trial. So here we are. We are wrapping up things very rapidly on